everybody. I've always seen the law as a powerful shield, a tool to protect the vulnerable and to uphold justice. And I grew up in a family of lawyers. My grandparents and my mother are all lawyers. And I decided to become a lawyer myself because I strongly believe in the power of law to effect change and to benefit society. But law does not always effect change and benefit society. The evolution of law is often shaped by profit motive and corporate interests. I've spent years in corporate boardrooms observing this. These are boardrooms where the interests of a corporate client in a specific dispute can outweigh the broader consideration of whether the underlying system of law in fact perpetuates injustice. The reality is that the majority of private practice lawyers do not engage with legal system design. They are simply not paid by corporate clients to do so. And so instead of being architects of legal systems for good, private practice lawyers often reinforce the legal systems within which they operate. This includes the positive aspects of those systems and the negative aspects of those systems. Today, I want to share with you an example of a legal system that prioritizes polluters over people and the planet and is in desperate need of redesign. Now, imagine that you find toxic chemicals in your blood. You live next to a heavy mining site, and while it's a matter of dispute whether the mining activities actually caused the toxic chemicals in your blood, your local government decides to shut the mine down just to be on the safe side. Now, what happens next is that the foreign investor that owns the mine launches a lawsuit against your local government to put pressure on your local government to reopen the mine. It asks for hundreds of millions of dollars of compensation. The lawsuit is launched before international arbitration proceedings, with international arbitrators deciding the case. Effectively, these are private courts with private judges. And even though you suffer the effects of toxic chemicals, you are not actually a party to this dispute. Now, what I've just described is not a theoretical problem. I want to bring you to Chatree gold mine. It's in Central Phuket province in Thailand. This is the first and largest gold mine in Thailand. It's operated by a Thai company that's owned by an Australian company, Kingsgate Consolidated Limited. Now, the Thai government had a team which was testing villagers who were living around the mine, and it was found that over 300 villagers, including children, had elevated levels of manganese and arsenic in their bodies. And so, even though the Thai government could not conclusively determine whether or not the mining activities had caused the poisoning, the Thai government decided to shut the mine down to be on the safe side. You would think the story would end there. But Kingsgate then launched an international lawsuit against the Thai government pursuant to the Thailand-Australia Free Trade Agreement. It asked for hundreds of millions of dollars in compensation. This dispute was before International Arbitration Tribunal. The villagers who suffered the effects of the chemicals were not party to these proceedings. After the lawsuit was launched, negotiations ensued between Kingsgate and the Thai government, and the mine was eventually reopened in 2022. Now, how could this even happen? How is it even the case that a foreign investor can sue an entire country? And how is it that a country can even be sued for trying to act in the interest to protect its own citizens and the environment? It's because the underlying system of international investment law is fundamentally misaligned with international climate and environmental efforts. The problem arises from thousands of international investment treaties that were entered into between countries at a point of time where environmental and climate protection was not a priority. Now, the Thailand-Australia Free Trade Agreement that's at the center of the Kingsgate dispute is an example of such an old generation treaty. These treaties contain very broad protective provisions for foreign investments and make almost no reference to sustainable development, climate protection, human rights, and other types of standards to ensure the environmental and health safety of citizens of the country. These old generation treaties also contain a dispute settlement mechanism known as investor-state dispute settlement. I'll be referring to this as ISDS for short. And ISDS allows foreign investors direct legal recourse to bring a lawsuit against a country in international arbitration proceedings before international arbitrators. So this means that if a state's regulatory acts affect the investment of a foreign investor, the foreign investor can directly sue the state. This is even if the state is acting to regulate, to protect the environment, to protect biodiversity, to protect human rights, to address climate change, and to protect the health of its citizens. This is even the case even if the state is acting to comply with its legal obligations in other international climate and environmental treaties, because both these systems are misaligned. Now, this isn't just a singular problem, it's a global problem. I want to take you to the coast of the Abruzzo region of Italy. In 2016, the Italian people won a victory for the environment. The Italian government responded to public protests and passed a law to completely ban all oil and gas extraction within 12 miles of this beautiful coastline. But a British exploration company, Rockhopper, had other plans. Its subsidiary held an oil exploration permit for an oil field off the Abruzzo coast. So when this environmental law was passed and effectively cancelled the project, Rockhopper launched an ISDS lawsuit against Italy. The arbitrators ordered Italy to pay Rockhopper over 190 million euros plus interest. Now, this amount of money was not just to compensate Rockhopper for its costs, it was also to compensate Rockhopper for the future potential cash flows that the company claimed would be generated from the production of the oil field. Now, bear in mind, this is an oil field project that had not even started because of protests of the Italian citizens. So think about it. You have a legal system which allows a country to have to pay over 190 million euros because it passed a law to protect its environment. And what's more, in this case, the citizens of the country actually supported the passing of that law. This case sends a chilling message that foreign investors' right to protect their investment is granted greater value than a state's leeway to protect the climate, environment, and to listen to its citizens. Now, this is a problem which is quite entrenched in the system. It's really notable to remember that fossil fuel investors are one of the most prolific users of the system. To date, over $77 billion have been awarded to fossil fuel companies. Now, that is $77 billion that could have been used by countries for their developmental needs and to benefit their citizens. Foreign investors have launched lawsuits against states for refusing oil and gas exploration permits, for attempting to phase out coal-fired power plants, and for introducing fracking bans. Several United Nations Special Rapporteurs have strongly criticized the ISDS system and say that it's fundamentally misaligned with international climate and environmental efforts. And this is also a very worrying problem for Southeast Asia. The ASEAN Secretariat has released a report that states that over 85% of international investment treaties that ASEAN countries have concluded are old generation treaties that do not reference sustainable development and are inadequate to address the needs of the just energy transition and climate protection in Southeast Asia. So, what can we do about this? Well, there are some international governmental efforts amongst countries to try and reform the ISDS system. These are primarily driven by United Nations bodies and international organizations, but progress is quite slow because it's very difficult to get consensus of multiple countries. But there is hope. International law is catching up. There has been a recent call to hold polluters accountable for climate and environmental impacts from no less than the International Court of Justice. The International Court of Justice is the world's most authoritative court that sits in The Hague, and it pronounces on international law, and its rulings impact on countries worldwide. So the International Court of Justice has recently issued a landmark advisory opinion pronouncing on international law. It has affirmed that states have a clear duty to act to prevent significant harm to the environment and the climate system. Specifically, states must act with due diligence to protect the climate system, and that includes through regulating fossil fuel production and exploration, fossil fuel subsidies, as well as regulating the activities of private companies. Now, this means that the ISDS system and the international investment treaties that underpin it must be interpreted in light of the International Court of Justice's pronouncement on what international law is. This means that within the interpretation of the specific treaty content, states now have a greater leeway to lawfully regulate to protect the climate and environment. This is an important legal tool that can be used to redesign the ISDS system. So how can all of us support the redesign of the ISDS system? Well, this is an effort which really requires grassroots mobilization, and it's important to understand that there are roles for civil society, responsible businesses, and for the legal community alike. For civil society, ISDS reform is important because even if you campaign domestically and you achieve a win by convincing your government to implement a particular environmental measure or take particular steps, this win can be undercut by a polluting company putting pressure on the government through an international lawsuit. So this means that advocacy must be quite specific to try to address the underlying legal rules that create this problem in the first place, and must be coordinated across different jurisdictions and between different regions. For corporations, ISDS reform is important because this system rewards environmental and climate laggards. So responsible businesses, they make good faith efforts to comply with a country's latest environmental and climate regulations, will be prejudiced if these regulations are subsequently rewound because of the pressure of an international lawsuit. It also bears noting that if a company purports to uphold ESG standards and also support environmental and climate protection, but subsequently brings a lawsuit against a government that's attempting to regulate to protect the environment and the climate, this kind of activity could potentially be greenwashing behavior. For the legal community, lawyers play such an important role in the ISDS system. Lawyers are the counsel for plaintiff corporations who bring the lawsuits. Lawyers are the counsel that defend the states that are on the receiving end of the lawsuits. Lawyers are the international arbitrators who decide the lawsuits. Lawyers are also counsel who represent local communities whose voices are often shut out of this ISDS system. And each lawyer has a choice to make. They have to choose who they wish to represent. They have to choose how to interpret the legal rules that form their judgments, and they have to choose which legal rules they wish to fight for. Ultimately, it will take the legal community, responsible businesses, and civil society to work together to redesign legal systems that are no longer fit for purpose. For myself, I want to advocate for legal rules that support environmental and climate justice. This has personal meaning for me because I wish to honor the principles and integrity that I saw my grandparents and mother emulate as lawyers and attorneys. Environmental and climate justice is so important to protect our families, our communities, and our shared spaces. And all of us can be environmental and climate advocates. So let's work together to redesign legal systems for good. Let's work together to rewrite the legal rules to make law a shield to protect people and the planet, and not a sword for polluters. Thank you very much.